Good afternoon. I'm Russ Feingold, President of the American Constitution Society, the country's foremost progressive legal organization. We have more than 200 student and lawyer chapters across the nation. ACS's mission is to shape the legal debate, nurture the next generation of lawyers, judges, and advocates, and ensure that the law is a force to improve the lives of all people. If you aren't already, I'd really encourage you to become a member of ACS. Go to acslaw.org, where you can join ACS and find more information about upcoming events and opportunities. I'd like to also encourage you to follow ACS on social media, including on Twitter at ACS Law. Just a couple of housekeeping notes before we begin. Today's discussion is being recorded, and the recording will be available on ACS's website at www.acslaw.org after today's program concludes. 1 hour of California CLA credit is available for today's discussion. Additional information and CLE materials can be found on the event page of the ACS website and will be shared with all participants in a follow-up email. I'm honored that ACS is co-hosting today's discussion. Ending state-sanctioned killings, prosecutors, and the death penalty, with our friends at Fair and Just Prosecution, whose network of local elected prosecutors have been in the vanguard of many of the prosecutor-led reforms seeking to create a more fair and equitable criminal legal system. As you'll no doubt hear from the panel today, prosecutors have an enormous amount of influence within our criminal legal systems, which is why prosecutor-led reforms have garnered so much attention in the past few years and why they can have such an immediate and meaningful impact. Perhaps nowhere are prosecutor-led efforts more impactful than when it comes to state-sanctioned killings, where decisions regarding how to prosecute a crime can literally have life and death consequences. Last year, a letter to President Biden from nearly 100 current and former federal, state, and local prosecutors, which Fair and Just Prosecution put together, declared that, quote, "our nation's long experiment with the death penalty has failed," unquote. Importantly, these leaders in the criminal legal system called on the president to commute the death sentences of all those currently on the federal death row facing execution, a priority for ACS and others in the ACS death penalty abolition movement. These prosecutors understand that public safety can only coexist with fairness and equity in a system that does permit state-sanctioned killing. And there's a clear trend of prosecutors pursuing fewer capital prosecutions. There were only 18 new death sentences in 2021, making it the 7th year in a row in which there were fewer than 50 new death sentences nationally. These numbers, along with the historic number of states that have abolished the death penalty in recent years, reflect our country's movement away from the death penalty. Still, when they happen, far too often capital prosecutions target the most vulnerable and marginalized among us: the mentally ill, the intellectually disabled, victims of abuse, and people from historically marginalized communities, particularly Black men accused of killing a white victim. Though its supporters claim death is a punishment reserved for the worst of the worst, it is more often imposed on those in our society who are disempowered and disenfranchised. We're going to hear more about all of this from impressive speakers we've gathered for today's discussion. So now I'd like to turn this over to Miriam Krinsky, the Executive Director and our co-host for this event, Fair and Just Prosecutions. Miriam, I'm delighted to have you and all the panelists with us today. Thank you.
Thank you so much, Senator Feingold. And really, I'd like to thank ACS for the work that you all do on this issue and for the inspiring work that you do on so many other topics. It is truly our pleasure and our honor to be partnering with you and to be working with elected prosecutors around the country who, as you noted, have come together to speak out on this issue and to really put their voices loud and clear in favor of the need to end once and for all a system in our country of putting fellow members of their community to death. We know that the use of capital punishment as we come together today is at historically low levels. 23 states have abolished it, 3 have moratoria in place right now. And we also know that over the past 40 years, the Supreme Court has gradually limited its use, prohibiting, as you referenced, the use of the death penalty against juveniles, against individuals with intellectual disabilities, against people who have been convicted of non-homicide crimes. But we need to go further. Those limitations, those steps are not enough. Our country stands alone. We are an international outlier, and that should be an embarrassment to all of us. The rest of the world, the developed world over time, has abandoned capital punishment. In 2020, we were one of only 18 countries, the only Western democracy, the only country in the Americas to use the death penalty. So this conversation, this line in the sand that we need to be coming together to draw could not be more timely. And we are so fortunate to have a great group of leaders and experts together to join us for the conversation. First, moderating our conversation, we are so thankful to have Elizabeth Brunning. Liz is a staff writer for The Atlantic. She has written extensively and passionately and thoughtfully and persuasively on capital punishment in the New York Times and in The Atlantic. And she both witnessed and reported on, and in an incredibly moving piece, one of the final executions of the former administration in early 2020. Carissa Degani-Tafty is the Commonwealth's attorney for Arlington County and the City of Falls Church. She's been in office since 2020. She's no stranger, even before that, to the injustices of capital punishment, having served as the legal director of the Mid-Atlantic Innocence Project, where she saw and sought to undo some of the mistakes, the tragic mistakes, that our system too often makes. Dan Satterberg is the prosecuting attorney in Kings County, otherwise known as Seattle. He served as a prosecutor for 3 decades, and he's been in his elected position for the last 15 years. Dan has witnessed an evolution on the issue of capital punishment, an evolution of that issue in our country, an evolution of thinking among elected prosecutors, and has gone through his own evolution in his thinking about the issue to now be one of the foremost and one of the most important voices among elected prosecutors for abolition of the death penalty. And Robert Dunham serves as the executive director of the all-important Death Penalty Information Center. He was previously one of the leading capital appellate lawyers in Pennsylvania, and he's now a nationally recognized expert on capital punishment. And we'll talk about some incredibly important polling that's been done recently on this issue. So Liz, with that, I'm going to gratefully turn it over to your capable hands.
Miriam and Senator Feingold, thank you so much for your introductions. I'm really excited to be with you today moderating this webinar. I've been reporting on the death penalty for several years now, and the situation with the death penalty has only gotten more critical. I think a lot of the times in the United States, we expect issues to just get better and better with time, but we're always capable of backsliding or taking steps backwards. I think we've all felt that way with capital punishment in the past couple of years. And so I'm very excited to have this conversation, especially as a pretty important lawsuit begins in Oklahoma on Monday. This is another course in gossip, which could be very meaningful, an 8th Amendment lawsuit having to do with the lethal injection protocol used in Oklahoma. I know it's one I'll be keeping my eye on. And so that conversation and many others are going to be in the news and going to be impacting capital punishment going forward. Just do a bit of housekeeping before we get into our conversation with our fantastic panelists today. We'll be taking questions towards the end of today's discussion. If you'd like to ask a question, please type it into the Q&A box at the bottom of your screen at any time during this webinar. We will be monitoring those. please don't use the chat functions to submit questions before for the Q&A, because we may be overlooking those questions. We may not be keeping track of the chat function. So just use that Q&A box at the bottom of your screen at any time during the call, and we will be checking in on those questions as we get towards the end. But for now, we're going to move into our fantastic panelists and talking about these issues in depth. So Parissa and Robert and Dan and Miriam, I want to make sure that we have an organic and free-flowing conversation that everyone feels free to jump in on. But to get things going, I guess I'll turn to Dan. In the spirit of our conversation, you've served as a prosecutor for more than 30 years. So how and why have your views of capital punishment changed in that time? I know they've changed across the board in the United States in that same time period. So maybe you could speak to your own journey as well.
Well, thank you, Liz. It's good to be here. Yeah, I was a member of the office in 1985, and I didn't try any death penalty cases then. Within 5 years, I was appointed to be chief of staff at the office. So in the state of Washington, we've had the death penalty since about 1980. And my job as chief of staff was to help the elected prosecutor, Norm Mailing, make that very difficult decision about, is this one of the cases that is deserving of the death penalty? And it was a long and involved process. So during those almost 40 years that Washington state had the death penalty, we executed 3 people who asked to be executed, who told their lawyers to withdraw all appeals, and we executed 2 people who contested the election. And I, like you, Liz, I watched an execution in 2010, the last one there. And I came to the conclusion that as the prosecutor, that I needed to be a truth teller, that I needed to tell the people of my county and my state that the death penalty doesn't work. It takes too long, it's too expensive, it really prolongs the agony of victim families, and I can go into that later. And it's really applied in what the Supreme Court called a freakish and wanton manner, and I can tell you a little bit more about that. But at the end of the day, my role, I thought, as the prosecutor was to talk about this failed government experience, this program of the death penalty that was really doing no justice to anyone. I've got a leaf blower right outside my window, so I'm going to wait for your next question and turn my.
Dan, thank you so much. So turning to our other prosecutors. So Parissa, you bring an unusual background to your role as an elected prosecutor, having previously built your career in innocence work. So how does your past experience and your past cases inform your views of capital punishment now?
Thanks, Liz. Thank you to the American Constitution Project. And Liz, I'm a big fan of your work and delighted to be here. I'm Parissa Degani-Tafti. I am the Commonwealth Attorney for Arlington County and the City of Falls Church in Virginia. And I just want to point out at the start that Virginia has executed in its history more people than any other state in the United States. So I'm coming at that I'm pointing at all of this from that perspective. But also, my first client was condemned to death 3 times. And one time it was in a trial that the Supreme Court of the United States called a kangaroo court. And because of Furman versus Georgia, his last death sentence was commuted to life. And he went on to become the editor of the most widely read prison newspaper in the country, The Angleite, where he was the first journalist to expose prison rape, won more journalism awards than I can even count, and worked with the producers of an Oscar-nominated documentary about Angola Penitentiary. He was called the most rehabilitated prisoner in America. I also helped represent a man who confessed to a crime he didn't commit and pled guilty to that crime precisely because he was afraid of the death penalty. It took 17 years, DNA testing, and multiple habeas proceedings to exonerate him. And he's not the only man on death row that later was proven to be innocent by DNA evidence. Over the course of the last 20 years, I represented clients who've been condemned to death on prosecutor misconduct, sloppy investigations, false confessions, junk science, bad identifications, and ineffective defense lawyers. I've seen innocent people condemned to death, And I've seen guilty people condemned in trials so flawed that they are just offensive to every notion of justice that we should have as a society. And all of this led me to conclude that, and I've said it repeatedly, if you follow me on Twitter, that there is no place in a civilized society for the death penalty, in a society that believes in fairness, rehabilitation, and justice. So when I ran to be an elected prosecutor in my community on the promise to never seek the death penalty, and I proudly supported the Virginia legislature when it voted to abolish the death penalty last year. And we became the very first Confederate state, again, the state that executed more people than any other state in the history of this country, the state that performed the first execution in this country. So we became the first state to abolish the death penalty.
Well, congratulations. I think it was a job well done. And it was very heartening to the entire movement, I think, that move by Virginia, especially. And so, you know, the move that I think Dan and Parissa describe is heartening in both cases, both prosecutors who have changed their views of capital punishment over time and people who are starting work maybe in defense or innocence moving into prosecution. So sort of new generation of prosecutors who are coming in predisposed to have a very critical view of the death penalty. These are both positive trends. But perhaps Miriam, turning to you, could you give us maybe a little bit of historical background here and a little insight? So prosecutors historically have been among the most ardent and consistent pro-death penalty constituencies. So what has that changed? Why has that changed in recent years?
Yeah, thanks for that, Liz. I think you're right that over past decades, prosecutors, and I think Dan captured that sentiment very well, have been very focused on not if we kill, but how we kill. And I think that there has been this illusory effort to try to fix a system that fundamentally is broken and just cannot be fixed. And I certainly saw that in the 80s and 90s when I was a prosecutor myself. I sat on our office's death committee over the course of those years. And I think what I saw were individuals struggling with how to make the system better, rather than really coming to terms with the fact that we simply shouldn't be trying to make it better, that this is a system that we need to be abandoning for a host of reasons. And over the last 6 years, we've been seeing prosecutors like Parissa come into office, and individuals who have been doing the job for decades, like Dan, having that, you know, sort of grappling with their conscience and having that awakening take hold. And they have more and more been coming to the view that we need to abandon this starting point. Some of them are coming to it for the reasons that have been alluded to. They think that the costs are too high. They think that we put victims and survivors through all kinds of decades of pain and suffering through this system. And then I think there are others who simply, from a moral standpoint, realize that this is not who we want to be. This is not a criminal legal system that when prosecutors think of their role as ministers of justice, this does not align with that conceptualization. And so we are seeing, as the senator referenced, nearly 100 criminal justice leaders who came together calling on our president to end the federal system of death penalty. And we are also significantly seeing what happened last week, which was a bipartisan group of 56 current sitting elected prosecutors, DAs, Commonwealth attorneys, prosecuting attorneys, attorneys general, who are currently in office around the country, who are recognizing the need that we need to come together and work nationwide for the end of the death penalty, that it can no longer be about how we kill, but about no longer accepting that starting point.
That is fantastic way to look at it going forward. And I think, you know, turning to Robert and talking about those kinds of big framework shifts, we're seeing changes, you know, right now, not just in the perspectives of prosecutors, but in public opinion. So last week, the Justice Research Group released a new polling report to which you contributed analysis on public opinion surrounding capital punishment. Could you walk us through some of those findings?
I would be happy to do that. And first, let me thank the American Constitution Society and Fair and Just Prosecution for putting this together and for all the work that they've been doing. We're seeing that pay off in terms of public opinion changes. In the 1980s and 1990s, there was high public support for the death penalty, reaching 80%. And Gallup's poll last year indicated that support for capital punishment in general was down to 54%. 54% of Americans at that time said that the death penalty was morally acceptable. That was a record low for the poll. The 54% support was the lowest in more than 40 years. And 60% of Americans said they preferred alternatives to the death penalty as the appropriate punishment for murder. That's really important. And I'm going to show you some slides here to explain why. That is really important because the American public, it turns out, does not support the death penalty that is actually administered in the United States. When we talk about preference of life alternatives or long sentences, and that getting nearly 2/3 of the American public, it made us think about, well, what do Americans think about who is actually being sentenced to death? Because they don't actually know that. And the death penalty executions recently and new death sentences have disproportionately been, as Senator Feingold said, directed at people who are mentally ill, intellectually disabled, significantly abused, and so forth. So the poll that was done by the Justice Research Group looked at these areas. And what we found is across the line, whether it's the US as a whole, whether it's Democrats, whether it's independents, whether it's Republicans, majorities oppose the local prosecutor seeking a death penalty against vulnerable defendants. So here we see the results for those with mental illness, and we're looking at 60% opposition. And that includes 55% opposition among Republicans, who are touted as being major supporters of capital punishment. When we look at the question of the execution of those with intellectual disability or close to intellectual disability, which becomes critical with US Supreme Court decisions actually allowing people who are intellectually disabled to be executed despite the constitutional prohibition on it, we see that 59% would oppose prosecutors seeking death penalty in those circumstances, including 58% of Republicans. And then people with traumatic brain injuries, people with organic brain impairment, who comprise a significant group of those against whom the death penalty is sought. We see overall 63% opposition, including 59% among Republicans, who are supposed to be the most supportive of capital punishment. And we've also seen a number of cases in which military veterans with PTSD are being capitally prosecuted. Just recently, Zane Floyd was the object of an attempted execution in Nevada. 61%, and he was an honorably discharged veteran with PTSD. 61% of Americans opposed that, including 56% of Republicans. Interestingly, there, the most opposed are independents, where 67% oppose seeking the death penalty against veterans with PTSD, and victims of abuse, victims of chronic trauma, victims who have been raped by a parent or had serious physical attacks during their childhood. 61% oppose the death penalty for that, including 56% of Republicans. There's a slight difference that we see when it comes to whether the death penalty should be pursued against those who are still, according to all the scientific evidence we've seen, still have developing brains and whose brains function the same as the juveniles that the United States Supreme Court says it's unconstitutional to seek the death penalty against. But the US public is split pretty evenly on that. Overall, 45% oppose prosecutors seeking the death penalty in those circumstances, whereas 46% support it. That's where we see the biggest partisan divide still. But once again, you have more than half of the population either unsure or opposing seeking the death penalty in those cases. So the death penalty is being pursued in areas that the public really doesn't want it to be pursued. And I think as the public becomes more and more aware of that, support for capital punishment will continue to erode. A second set of questions, and I won't get into all of this because of the time, was whether prosecutors should seek commutations for defendants who are already on death row, who have these kinds of impairments. And generally speaking, the answer is yes. About half of those polled said that prosecutors should be seeking clemency. About a quarter said they didn't know, and slightly more than a quarter opposed that. So what we're really seeing in the poll is the same pattern that we're seeing across the board. Support for capital punishment is eroding. It's eroding geographically. It's eroding based on local results for elections of reform prosecutors, and it's eroding in that Americans support less and less the use of the death penalty as it is actually being carried out today.
Rob, thank you so much for that fantastic overview of where we stand on the issues. So, we might back up here as we move into our conversation. So, it's been 46 years since the Supreme Court brought back, after a fairly brief moratorium, the U.S. death penalty. This is after Furman, which is when the United States federally and on the federal level shut down the death penalty after a Supreme Court decision that found that the way that the death penalty was applied essentially made it totally arbitrary and capricious, right? There was really no predicting who was going to get it. And the reasons people were being given the death penalty versus other punishments were completely unrelated to the substance of what they had done. And so for a while, you just couldn't seek it. When the courts brought it back, it was after the death sentence had been broken up, the sentencing phase had been broken up into a separate phase of trial, right? So then you have guilt and innocence, and then you have sentencing in capital cases. After that, it's used to punish only the most extreme of crimes, the worst of the worst. And yet last week, Fair and Just Prosecution released a joint statement signed by 56 elected prosecutors arguing this promise has never been fulfilled. So, in what ways has our capital punishment system failed to live up to this promise? In the post-Furman world, we were supposed to get capital punishment with less guesswork, that was less arbitrary, less capricious, more scientific, more focused on the worst of the worst. And we're just not there. So maybe, turning to Miriam for a moment, how come we never got there?
Yeah, so I think that's a great question, Liz, and maybe in part the answer is that the Supreme Court's premise was simply a faulty premise, that there was a there we could get to, that it was achievable. When they reinstated the death penalty in '76, as you noted, they did so on this assumption. The assumption was that well-crafted states' laws could really ensure that this was going to be used in only the most extreme cases, only as it related to the worst of the worst. But as your comments reflect, and as Roberts and others reinforce, and frankly, as Roberts' recounting of the polling makes clear, as our public has assumed, but now we see has misassumed, this has not been used and limited to the worst of the worst. What we have seen in many instances is not the most culpable, but the most broken, the most vulnerable individuals, using the death penalty when individuals have suffered unspeakable trauma, when they have brain injuries, when they're not able to fully appreciate the nature and consequences of their acts, when they have suffered intellectual or are dealing with intellectual disabilities, and in instances where there were procedural, systemic breakdowns, where they were represented by trial lawyers who were derelict in their duties, when there wasn't access to discovery, when things were kept from them, when all white juries were returning this verdict, to a point where we now know that at least 20% of the people on death row are individuals with serious mental illness. And we also know, as Dan's comments referenced in passing, that some are just giving up, that around 10% of people executed since 1976 are what are so-called volunteers. They've simply said, I want to be done with this. Just put me to death. And I think, again, we have to ask ourselves, how did we get here? And is this something that we are okay with? And I think in answer, maybe again to your question, to assume that we can fix this is just the wrong starting point, because I think that premise was the wrong premise, and where we are over these years has reinforced the misimpression that this could potentially be fixed.
So Liz, I want to jump in on that, because even when things go right, when there's no travesty in the courtroom, there's still a freakish and wanton and really random aspect to the death penalty that we don't always appreciate. And I'll say, for instance, one of the things in my state, we have a lot of rural states, we're very conservative, but are also very poor. That's where you'll find the greatest support for the death penalty in theory. None of those counties could afford to fund a death penalty. Now, so the last two that we had in King County, the trial cost for the public defenders or the defense team was in excess of $5 million, and it took more than 3 years to get the case to trial. So the rural prosecutors who talk a good game know quite well that their county commissioners would never support. They'd get run out of town if they tried to seek the death penalty. They can't afford to do it. Now, another thing that happened in our county, we had the most prolific serial killer in America, at least one of the top 2 or 3, a guy named Gary Ridgway, who was the Green River Killer. We were able to, he was called the Green River Killer because he dumped his first 4 victims right along the Green River, and we had pretty good DNA evidence, although it was 20 years old. And so we charged him ultimately with 7 counts and sought the death penalty. And we were trying to apply the death penalty in a very principled manner. And then one day the defense attorneys came to us and said, he would like to help you uncover as many other victims as he can if you would take the death penalty off the table. It was a very difficult decision for the prosecutor at the time, Norm Mailing, but ultimately he thought that seeking the truth in those cases was more important than seeking the death penalty. Ultimately, we were able to clear 49 cases, return about 4 or 5 different remains to victims' family for proper burial, and to find the truth about this crime that haunted us for so long. And what we gave up was the death penalty. Now, I thought it would be over by then, but the Supreme Court found a way to keep it alive and keep it alive and kicking. And so finally, I was seated with a victim's family in 2010 at the Walla Walla Penitentiary and watched a man put to death by the state of Washington. And it was a terrible case. I won't go into it right now, but the victim's sister came and was sitting next to me, and she said, now, after we watched him die, she said, now we don't have to think about him anymore. And for 20 years, his case was on appeal. It had been up to the U.S. Supreme Court, had been through the Court of Appeals many times, federal and state, and they lived in fear that some judge sometime was going to let that guy out. And they wanted to make sure that that didn't happen. And I thought to myself at that moment that we could have spared that family at least 17 of those 20 years of worry, because if we had sought simply life without possibility of release for him, that case would have gone through the trial process and the appellate process in about 3 years, and they would have been done. So that was the moment I had my epiphany. Like all good epiphanies, it took years to come, and it happened all at once. It's like, this doesn't serve victims at all. And all of the families that I'd had to meet with as the chief of staff or as the elected prosecutor, after they suffered a terrible murder, one of the first things I had to bring up was, this crime qualifies for the death penalty, and I'm going to need to know what you think about that, because I've got 30 days to file a notice or not. And at the time when they were suffering so much, that putting that on the table just divided families. It made them mad. And then ultimately I'd come back and say, well, we decided not to seek the death penalty, and then I was the enemy. So it was something that was very hypothetical for a long time. Like I said, we had 2 contested executions in nearly 40 years, but we spent tens of millions of dollars pursuing this failed government program. And at the end of the day, it just put victims through such a tough time, and it was needless. And so I was I came out against it, and then about 2 years later, the state Supreme Court in Washington set it aside as racially disproportionate. We haven't even gotten to the racial history of this or the disproportionality in race, but that was the reason that the state of Washington doesn't have one now, because the state Supreme Court ruled it unconstitutional. I was before the legislature twice before that, asking the legislature to get rid of it. I think a lot of people have the opinion, contrary to what Robert just shared with us, that this has vast support among the American people. I think that is waning very quickly. And I look at my children, and I know they're gonna think the death penalty is really an anarchistic kind of thing. It's like, what were you guys thinking about? Why would you put someone to death when you've got LWOP as a substitute?
Well, right. And so to turn to Robert, you know, speaking of the work that the Death Penalty Information Center has done, you know, the fact that the death penalty remains totally arbitrary and capricious and sort of difficult to situate in a criminal justice system that I think is under increasing pressure to explain itself, especially from kind of a new generation of activists that are concerned with criminal justice, race, fairness, and accuracy in arrests and sentencing, and just greater accountability altogether from the criminal justice system. You know, have you been finding a greater audience or a renewed interest in the sort of findings that you have been putting out? And could you say a little more about the findings that you have regarding what Miriam and I were discussing earlier, the continued arbitrary capriciousness of capital sentencing?
You know, there's a catchphrase that you can use to describe the arbitrariness of capital punishment, and it's race, place, and time. And I know we'll talk about race and looking at the data. What he was able to find is that, you know, you can't make two murders exactly the same over time, but looking at similar characteristics, a murder committed in the 1990s, it was tried in the 1990s, was 5 times more likely to result in a death sentence than a similar murder tried in the 2010s. That isn't because murders are worse. It isn't because they are substantively different than they used to be. It's because of a whole bunch of things that can fit in this description of time. The differences in public attitudes about the death penalty, the differences in the quality of counsel, and so forth. And that means that we are just chronologically time arbitrary as well. And now we talk about issues like deterrence, and we'll talk about that more later on too. But the fact is that more than half of everybody on death row has been there more than 20 years. And even if the death penalty had any deterrent value, and there's no evidence that it does, it would have none if on average it wasn't carried out for more than 20 years.
Thank you very much. And so, you know, talking about that issue of time, Prissa, you have worked on the innocent side and now on the prosecution side. We've had so much time to make reforms, and there have been significant reforms, as we discussed at the beginning of the webinar, in terms of how the death penalty can be applied. There have been massive changes to the sentencing process in terms of you know, whether the death penalty can be applied in cases of mental illness. There's been Atkins in cases of intellectual disability, crimes other than murder, so on and so forth, juveniles. After decades of reforms, why are we still where we are with the death penalty and all of its flaws?
I don't have a long-winded answer for that, but I think ultimately you can't have a procedural solution for a moral problem. And we can ask all of those questions that you asked, that you talked about just now, the questions that the Supreme Court of the United States has looked at since Blackmun's dissent, where he said that he would no longer tinker with the machinery of death. You know, should we execute kids under 16? How about kids under 18? Should we execute people who are developmentally disabled or mentally ill? You know, should we allow execution methods that cause suffering? should we allow defendants to be put to death because their lawyers were incompetent or because a filing deadline was missed? And at the end of the day, we can add layers of process, but no matter how many layers you add, it's always going to be too flimsy a structure to hold back the larger institutional and historic forces that have always driven the death penalty. And one of those is racism. Another one of those is what I call sort of the fetishism of finality. When I'm teaching young lawyers and when I was teaching interns at the Mid-Atlantic Innocence Project about the various layers of appeal, one of the things that comes out is that you can have a dozen layers of appeal, but none of those layers are the courts re-examining facts. None of them are they really delving into the adequacy of counsel in a truly important way. They take apart, like the counsel did this wrong and that wrong, but they don't ever take the holistic view of, was this actually good representation or not? So, unless you're peeling back, all of the layers, you're not really peeling, unless you're peeling back the biases of the actors in a system and the fact that it is a system that sort of runs on autopilot. What you get is 0 + 0 + 0 as many times and as many layers of review as you can have, but 0 + 0 + 0 always equals 0, and it's never going to account for, like, all of the never-ending series of questions are never going to actually solve what is such like a systemic, a historic, a societal, and a moral problem.
Liz, I'll add what I have found when I am debating with people either in the legislature or people, my constituents who were mad at me that I had given up on the death penalty is that they're arguing from a perspective of the criminal justice system that they wish we had, the imaginary one that happens really quickly and is never wrong, and not about, they don't know what happens in the system. So I would encourage prosecutors and people in power to be that truth teller, to come out and say, you know what, it takes at least 20 years. And did you know that if you're in a small county, you'll never seek the death penalty? And did you know that victims are put through all of this terrible trauma? Now, I've also seen victims weaponized in this argument and gruesome facts used to support the death penalty. And I've seen a lot of gruesome facts in my 37 years in the office. And, you could say that they all deserve the death penalty, but my question is, what do we deserve? And we deserve a system that is fair and that works as promised. And I don't want to delve into someone's imaginary criminal justice system anymore. I want to be the truth teller that tells exactly what happens in this. And the more that we tell the truth, the more that people will realize, even hardcore conservatives will realize, this is not a government program that is worth investing in anymore.
So what do we say to people who, I think especially in the upcoming midterm elections, public safety and crime are going to be major issues. I think that's been telegraphed quite a bit. And so, I guess this is something that I can pitch broadly to all of you. Sort of what response do you have to people who say, well, I'm just worried about public safety. I'm worried about crime. If we take the death penalty off the table, what's to stop somebody like a Gary Ridgway or a Ted Bundy? There's enormous interest as well in true crime. I wonder about the social utility of that genre all the time, but, people seem attached to it in certain quarters. So what's your response to those kinds of concerns?
Well, I would start by saying, if you think that people who commit homicides are rational actors, and that's a big if, most of the time it is a crime of passion and not premeditated. But if they were rational actors, and if they considered the chance that their case was going to get the death penalty, that they would actually be executed, then a rational criminal would say, well, my chance of that is about as good as being hit by lightning or winning the state lottery. It's about 0. So if the death penalty is going to be a deterrent as applied, it's no deterrent at all.
Right. I mean, Robert, what do you think?
Well, it's clearly not a deterrent as practiced, but what we wanted to do was check to see if it was a deterrent in any meaningful sense. If the death penalty reduces murder rates, which is what it's advertised as being able to do, then that's a reason to have it. And if it makes police safer, that's a reason to have it. So we looked at 30 years of FBI homicide data. And what we found was that states with the death penalty consistently had higher murder rates than states that didn't have the death penalty. Whether or not a state had the death penalty had no effect on trends. So when murder rates went up in the country, they went up whether you had the death penalty or not. When they went down whether you would abolish the death penalty or not. And we found, and this really surprises people, that police were safest in states that had most recently abolished the death penalty. The other states in which they were more safe were the ones that didn't have the death penalty at all, or the states in which they had the death penalty but wasn't being carried out. That makes no sense at all if the death penalty is deterrent. We found that murder rates didn't increase after states abolished the death penalty compared to states with it and states that never had it. And we found that the presence or absence of the death penalty had no effect on murder rates. It had no value as a deterrent. So this is true with respect to police. It's true with respect to the public in general. The death penalty has not, does not, and will not improve public safety.
Parissa, and I would just like to remind everybody before we get to our final few comments here to submit questions in the Q&A box. If you have any questions for our panelists, we'll be moving to Q&A likely after I ask Parissa about the issue of race and the death penalty. And I want to ask you about this just because you've had so much hands-on experience doing innocence work and defense before moving into prosecution. I mean, it seems like such an enormous problem. It's hard to really get my arms around. And I guess one issue that I think about all the time as a journalist, and I'm interested in reporting, and I'm also interested in persuasion, is, you know, it's such a tense issue that I feel as soon as I bring up the issue of race and the death penalty and bias and race and the death penalty, I've potentially already lost, you know, half my audience who might be willing to hear me out. So how do you bring it up in the broadest and most persuasive terms possible?
Well, I do like data, and I will cite some data, but I think that there's, you know, when I talked about the societal problem earlier, I think all of what we're talking about harkens back to some pretty sort of deeply held fundamental racist ideas that we have as a community and as a society. And it really goes to the false myth of Black dangerousness. And it's a myth that was promulgated in order to justify slavery. And it's a myth that holds that it held at the time to justify slavery, that if Black people were not contained by the institution of slavery, that they would otherwise become criminals because of a supposedly savage nature. And the false myth was so strong that even abolitionists bought into it. And it was so strong that when we had a progressive era, you know, after the turn of the 20th century, that came to believe that criminogenic behavior was the result of social and economic circumstances, it only believed it and applied those principles to European immigrants. So this false myth, I'd say, is like one of the rotten building blocks of the death penalty. And I want to just take a second to focus on Virginia, where in 1848, white people could only be executed for premeditated murder, but Black people could be executed for anything that, had they been white, could result in a 3-year prison sentence. That was literally explicitly the law. And immediately after the Civil War, Black codes sort of increased the list of offenses for which incarceration could be imposed. And that effect was felt immediately by the Black population, both in the increase of disproportionate numbers, because around the Civil War, it was about even to the proportion of the population. And then it just exploded after that. In fact, to the point where in the 2010 census, it showed that whites were 65% of the population and 37% of the incarcerated population. But in contrast, Black people were 19% of the general population and nearly 60% of the incarcerated population. And, if you look at, again, Virginia, from 1900 to 1977, Virginia executed 73 Black defendants for rape, attempted rape, or armed robbery, and executed 0 white men for that crime. In the whole of the 20th century, 78.5% of the people executed in Virginia were Black, when the Black population of Virginia was only about 20%. And nationwide, people are still more likely to receive death sentences if you're Black than if you are a person of color, than if you're white. And I think it's 43% of executions since in the US were people of color since 1976. And it's not just the race of the person who is accused and convicted, but it's also the race of the victim. And cases involving white victims were far more likely to lead to death sentences than those involving Black victims. And I think the percentage is 75% of death penalty cases involved murder of white victims. And I think there's stats in Washington that Dan probably knows of better. There are stats in Louisiana where from 1990 to 2008, the odds of a death sentence for someone who had a white victim were 97% higher than those whose victim was Black. So I think that we cannot look at this, and we cannot look at the numbers outside of the historical context of what the last 400 years have been in this country, and that we have perpetuated myths about people and inherent dangerousness, which are completely false and which were created in order to justify treating human beings as property.
To begin the Q&A section of this conversation, thank you so much, Parissa and Dan and Robert and Miriam, for your fantastic contributions so far. We have a lot of questions. I'm going to try to hit the high notes here, and I'm sorry if I miss your question. Someone asked something that's very intriguing to me personally, which is it acceptable to seek or impose a sentence of life without the possibility of parole as an alternative to the sentence of death? So this is the sort of next frontier of anti-capital punishment work for me, is this question of LWOP and whether that's an ethical alternative. I think that the anti-death penalty, the abolition community is sort of split on that. So Miriam, what do you think?
So I think that's a great question. And I do think that there are also concerns about life without parole, and that if we want a system that recognizes that people deserve second chances, if we want a system where, frankly, even correctional leaders would like there to be some incentive for individuals when they're behind bars to improve themselves, to not engage in behavior that is going to create problems and difficulties. I think we do need a system that provides an opportunity, with checks in place, for people to be able to come back to society when they no longer pose a risk. And I don't think it needs to be an either or. I don't think that we need to presume that to effectively eliminate the death penalty, we have to be willing to accept life without parole sentences. We can readily have checks in place such that if people continue to pose a danger to the community, they don't return to society. But that doesn't mean that we need to forever give up on their ability to come back to the community, to age out of behavior that caused them to be behind bars in the first instance.
I'll say that it helped a lot in eliminating the death penalty in my state that there was an LWOP. And if there was a possibility that the person could be out in, the minimum time for parole review, then the politics around that would have been much more, I think, intense. And I'll say also, if our interest is giving some sort of finality of the legal process to victims' families, then telling them they have to come to a parole hearing in 20 years and argue to keep their killer of their daughter in prison, that's really a lot to ask people to do. So I think there's a benefit of LWOP for the extraordinary case, the Ridgeway case with 49 victims. I've got several with a dozen or more, people who they've killed, or a half dozen. So it's a tough thing. I know we're taking baby steps, but if you want to get rid of the death penalty in your state, I think it's good to have an LWOP to be able to assure people that the worst of the worst are not going to be walking free.
One of the most interesting things about this is that it depends on whether you're viewing the death penalty as a symptom or the death penalty as a disease. If you're having a broad view of the criminal legal system itself, I think it's clear that the death penalty legitimizes other harsher punishments, and accepting abuses in capital punishment in some way diminishes those abuses when they occur in non-capital cases. So we'd have a very different discussion about life without possibility of parole if it were not being legitimized by the presence of capital punishment. If you're viewing the death penalty as the disease as opposed to a symptom, as Dan said, it is extremely useful to use legislatively because it is an assurance that people are never going to return to the streets. There's a lot of evidence that shows that the society is and the corrections system is able to distinguish generally very well as to who is dangerous and who is not. But there are these occasional examples that were brought up with Willie Horton in the 1980s in the presidential campaign where they're failures and they have enormous political implications. But again, I think it comes down to the death penalty legitimizes all the other harsh punishments in the American legal system.
I think that's right. And I think that one more question, and I want to open this to all of you broadly as a sort of conclusion, is sort of what's next? Do you imagine that the way that the death penalty ends in the United States is legislative? Does it sort of die state by state in courts? Is it just inevitably going to be delayed or just sort of condemned to these sort of uncertain moratoria that are, sometimes overturned, as we saw with Trump and Barr and the Roe litigation? What's next for the United States and the death penalty?
Well, I'd love to see President Biden commute the sentences of people on death row right now, which would effectively stop the federal death penalty, I think, and create some litigation if Congress isn't going to do it. I don't think the federal government has any purpose having the death penalty at all. But ultimately, I think it's the kids that come in, the young people who aren't even in law school yet. They're going to be the ones who get here and say, we don't want any part of the death penalty. It doesn't work. It's cruel. And when it's wrong, it's spectacularly wrong.
In much of the country, the death penalty is eliminating itself. And we're seeing every year or so, state by state, a new state is abolishing the death penalty. And at the county level, 80% of the counties in the United States don't have anybody who is on death row. And with the election of reform prosecutors, if we just take a look at the letter that was sent last week, 6 of the prosecutors who signed the letter are from counties that 1 decade ago were in the highest 1% in terms of death row population. And just those 6% of those 6 counties constituted 14% of the nation's death row. The voters at the local level are eliminating the death penalty. What we're going to see, I think, is a continued geographic retrenchment. There is no death penalty north of North Carolina along the Atlantic coast. There is no execution that's authorized in the entire length of the Pacific coast. So we're going to see continued geographic erosion. And even in states that carry it out, there are fewer and fewer new death sentences being imposed. But when 5 counties in Texas and Oklahoma account for 20% of all the executions in the United States, and the states of Texas, Oklahoma, and Missouri combined account for more than half of all the executions in the United States over the last 50 years. I think it's clear there are certain states in which abolition will have to be imposed on them. And that will only happen a very different Supreme Court in another generation.
I agree with Dan that I would love to see Biden take a lead on this issue and issue a moratorium. I would love to see the administration create a task force to study some of the reform prosecution work that we've been doing, because it does make a difference. My predecessor charged 4 people with capital murder. I've charged 0. And she charged people with capital murder on the theory that the community should weigh in on what happens in those cases. But in every single one of those cases, there ended up being a guilty plea. So the community had nothing, had no voice in that. I think that focusing on the reform prosecutor movement is extremely important. And this is going to sound like sucking up to Liz, but I'm going to be honest that the piece that now where you witnessed the execution and you ended up saying that you thought that this was supposed to be cathartic, but you just felt a sense of shame. And that nobody got anything out of that. And I think you ended it with nothing. I feel like that kind of journalism is really important to lifting up the truth about what this is.
I guess maybe to wrap, Liz, in terms of what's next, I think more and more, and it was referenced in one of the great questions that was posed to us, we are going to see this nation start to realize the outlier that we are in imposing life without parole, no opportunity for second chances, and the horrific outlier we are when it comes to the death penalty. And I think we are going to see, as public opinion continues to embrace the need to change that, the need for us to better align and solve the entire disease, as Robert put it so well, not just a singular symptom of that disease, we're going to see more prosecutors, elected prosecutors coming together. I think we're going to see more who, as was said by 56 of them last week, we have varied opinions surrounding the death penalty, but we've all now arrived at the same inexorable conclusion. Our country's system of capital punishment is broken, and it's time to work together towards systemic change that will bring about elimination of the death penalty nationwide. I think we're going to see more voices come together. I think we're going to see more leaders make choices like Parissa and Dan are, of simply not doing it case by case and championing the need for change. And so I want to again thank you, Liz, for moderating the conversation, for the work you do, Robert, for the work that you do in trying to lift up the need for change on these issues, and elected prosecutors like Dan and Parissa, who are champions of the need for that change. And of course, I want to thank our wonderful partners at ACS, as well as some incredible behind the scenes members of the FJP team, Rebecca Blair, Alyssa Kress, Ruby Deary, and a host of others, for setting the table for the conversation today. So we appreciate everyone staying with us a couple minutes late. And we hope you carried this conversation on in your jurisdictions, in your jobs, in your law schools, and around the nation.